Welcome back. You're on the legal line with Dennis Kennelly, and we're with our guest today, Professor Corey Field, an entertainment lawyer and also a law professor at USC Law School. And what we're going to do now is to go over one of the most common situations that entertainment lawyers face. And this is the phone call from either the parent of the kid in the basement dreaming about his musical future, or the artist himself. And a typical situation, the guys and gals get together a band, and somebody hears them, and there's a song that the band played that somebody in the band wrote, and what are we going to do about it? Who's got what rights in it? So, Corey, take it from there.
Okay. Well, this is that sort of like young musician starting out thing. Often by implication, it is a parent who phones me, a friend of a friend who says, hey, I hear you're a copyright and music lawyer, and, I want to tell you about what's happening with my 14-year-old, and something has come up. And your scenario is very realistic, because that phone call often happens when there's a development that starts to touch the business side. We were talking earlier, there's the creative side and the business side, and very often the creative side works pretty well until it walks through the door into the world of business, and then suddenly there's questions. People start thinking about, well, who owns what? Like you said, a member of the band wrote the song. Right there's often things that people didn't think about, like, well, who was the songwriter? Was it just that one member? Did someone else add something? Did they all add something? Who actually created what? And those are the things that happen creatively by instinct. And then along come later the entertainment lawyer, the music industry, and they want really specific answers, like, we actually need to know which of these four kids actually wrote the song, because there's certain rights that songwriters have, there's certain income that comes to songwriters, but we've got to figure out who it is. And so one of the first situations, and incredibly common, is that people collaborate on songwriting. It might be just one person whose buddy comes along and they work two people on a song, or it might be a band doing a song and they're all kind of contributing something. And the question is, well, whose is it? Who wrote the song? Who does it belong to? Because, you can have a situation in a group where, let's say there's 5 people in the group, and 3 of them wrote a song and 2 just didn't. They just had nothing to do with it. Well, you're going to have 3 of them getting extra money for their songwriting and the other 2 not. And so right away, there's potential conflicts there, like, why aren't I getting the. So the job of the lawyer is to sit down and say, okay, who did what on the song, who actually are the songwriters, and try and figure out what's accurate. I mean, basically, what people don't do when they're in the throes of artistic creation is they virtually never say, wait a minute, who owns this? Who's writing it? Let's be lawyer-like. No one does that. And so the job of the lawyer is often to come in later and say, well, what actually happened and who agreed to what? The nice thing about copyright law is it actually protects things very often from the very beginning. Copyright law says whoever created something is the original author and copyright owner. So sometimes just finding out who did what kind of answers the copyright question. But that's kind of like a typical thing. I don't want to go on too long about it, but on the songwriting front, it's kind of like a conversation of like, okay, well, who contributed to the song? And where it gets interesting or scary or dodgy or whatever you want to say is some contributions to a song don't really make someone a songwriter. Like, let's say me and your engineer today, Aaron, are really working on a song together. And Dennis, you come along with your drum set and you kind of hit the drum a couple times. So who are the real songwriters here? It's probably really just me and Aaron. And you provided a little bit of a drum accent. You're probably not a songwriter. But what if you say you are? What if you say, wait a minute, The three of us wrote it. My drum beat was just as important as the tune and the lyrics. That's where you can get into a dispute of who's a songwriter and who isn't. I hope that kind of makes it a little clear.
I think it does. Now, you use the term copyright. Everybody has an idea of what that is, but why don't you explain what a copyright is and, as importantly, when you should get one if you're a songwriter?
Well, copyright, I'm a big fan of copyright. Some people call me a copyright lawyer, others call me an entertainment lawyer, but copyright is the law that protects what people create artistically. Think about that. How amazing is that? Anytime someone writes a poem or a novel or writes a song or paints a painting, they've got ownership of that. It belongs to them, and copyright law is the law that says, this is yours, you own it. Or you don't, depending on what side of the facts you're on. So copyright law, it incredibly follows a very sort of human creative philosophy in certain ways. And what I mean by that is if you write a song and there's some originality to it, you can't just be like singing one note for 5 minutes and say you're a songwriter. You got to do something. So there's something original there. As long as you write it down or record it and make it tangible, make it more than just an improvisation that disappears into the air, you own the copyright automatically. That's how great this law is. It protects creativity. If you do something original and you make a record of it, write it down, record it, photograph it, you own the copyright. And that's the United States copyright law. I mean, it's very powerful. And if you're a band and you're two people creating something together, and you both are agreeing on that, saying, yeah, we're doing this together, we're Lennon and McCartney, we're Rodgers and Hammerstein, we're doing it together, then copyright law assumes that you're each equal owners. I mean, it takes care of a lot of things sort of in a very natural, logical way. Now, what happens later is that there's ways to protect your copyright. Many people have heard about registering your copyright at the Copyright Office in Washington, D.C. That's a really good idea. It gives you extra protection. It tells the whole world that this is your copyright. But believe it or not, you don't actually have to do that initially. All you really have to do is be the creator. I mean, copyright law is kind of amazing that way.
So what you would do is take a careful notation of what you created and when you created it.
You're right in practice and theory, but let's be real about the band in the basement. They're never going to do that. They're never even going to have a conversation about, by the way, which of us are the copyright owners, which of us are it's never going to happen. It's only like maybe the lawyer's children who might do that, at which point the other band members will say, you know what, I'm going to join a different band. This is ridiculous. That's what's
too much
happen.
Paperwork.
Yeah, too much. I mean, are you kidding me? Like, this is all about your dad, the lawyer? No. So, realistically, people don't do that. And most of the time, this actually works out pretty well. A songwriter creates a song. Maybe they clearly collaborate with someone. And if they're successful and the lawyers and the publishers and the record labels show up, then as long as there's that sort of clear path to who created what, anecdotally, then it's going to work out. The lawyers and the labels and the publishers will know just what to do with that information. Now, what does happen is there can be disputes. My example of you adding a few drum beats to the song that me and your producer wrote, that happens all the time. What's very common is someone's a songwriter and they have written a song, for example. I've heard this story dozens, if not hundreds of times. I won't say thousands, that would be an exaggeration. And a friend of theirs who's a little more experienced, maybe they produced a record, says, hey, I'll come work on your song with you. And what happens is they improve the song, and the original songwriter, from their perspective, it's still their song, and all that's happened is their friend has sort of acted like a producer and kind of improved the sound and maybe had a couple good suggestions. But that producer might be thinking, you know what, I came in with the song that was sort of halfway done, and I'm now an equal songwriter. I've improved it so much. We now have two songwriters, and this is a really common situation that can occur. Look, in the perfect world, the songwriter would tell the producer, I'd love for you to help work on my song. I just, and forgive me for even saying this, and I know that this is all about creativity, and I love you, but I just want to make it really clear it's always going to be my song, right? And honestly, someone who's brave enough to have that one-sentence conversation does themselves a world of good. They avoid any misunderstandings, because if that producer then says, oh, no, I was thinking we're now co-writers of this song together, then there's an opportunity to just stop and say, oh, dear, we've got a misunderstanding, maybe we shouldn't work together. Or, of course, to say, that's fine with me. Let's be co-writers. I love it. I'm honored. So it's that one sentence that if someone can just utter it, makes a world of difference when people start writing songs together.
Exactly, because what you want to do is don't get into the assumption business, because the scenario that you've dictated without that one sentence about I want to be a co-writer, or don't think of yourself as a co-writer, is going to lead to assumptions, which are going to lead to fights. I mean, we've brought other people into London Rain songs, for example, and we agree on a percentage that we're going to try and sell this song, and we're going to give you 15% of it. Because we think you deserve 15% writing credit on a particular song, and that works. And I think
you're a good lawyer, Dennis. You're a good entertainment lawyer. That sounds good to me. Clarity, a good business decision, everybody on board, and then you bring out your little contract, and everybody signs it, and you're good. Well done.
Exactly. Which is what you're trying to avoid is when, as you said, when the rubber meets the road and creativity moves into the land of money. That's when these ugly things start to raise their heads if they haven't been dealt with in advance.
It can happen. It can happen.
And another one is, you've got the five guys in the basement, and you've got the lead singer is also the songwriter. But the way money starts to potentially flow is somebody hears the band at the club, down around the corner, and the band plays the song, and the record label gets interested and says, hey, we would like to record this song. What rights, if any, do the other band performers have in that particular venture? Let's say that the XYZ record company buys the song. What happens? Do they have any rights at all?
Well, what we're getting into now is the other side of the music business, which is being an artist, being a performer, being the person who actually makes, the sounds. And, historically, if you think about it, it used to be that the famous performers weren't necessarily songwriters. I mean, the era of Frank Sinatra and Elvis, they weren't actually known for their songwriting. They were performers who would perform something that someone else wrote. And the Beatles kind of changed that big time. The Beatles wrote their own material and were their performers, and sort of started the music business on that path to a significant extent. And that often is really confusing to people, because when you have the same person or people they doing songs, they wear two different hats. Some of them are wearing the I'm the songwriter hat, and some of them are wearing the I'm the artist, the performer hat. Think of the Beatles. So for most of the Beatles songs, not all of them, here's what you had. John, Paul, George, and Ringo were all performers. They all had a record deal. They were all being paid by their record label to make records, all getting record royalties. They were playing live concerts, all getting paid for the live concerts. I think, without knowing for certain, that they divided all that money 4 ways equally. And so all 4 of them participated in that part of the business. They signed record deals, they're on records, they're performing, they're playing live, and that's their artist hat. 2 of them had an additional 2 hats. Lennon and McCartney were also songwriters, and they had a completely separate additional income stream, because when those records were made, it was their songwriting in the record. And when those live concerts took place, it was their songs being performed live. So what happens in your scenario is, if there's a record deal, then everybody in the group has got on that hat of, I'm an artist, I'm signing the record deal, I'm going in the studio, I'm getting royalties from the records, I'm playing live, I'm getting paid for the live gig. But then perhaps only one or two members, like Lennon and McCartney, they're going to also have this entirely separate and additional songwriter income. And so that's kind of one of the biggest points about the entire music industry is to never forget the difference in how the money flows between an artist who's actually a musician making sounds, singing or playing an instrument, and a songwriter who is writing the song and getting paid additionally and separately. And what's so confusing for even lawyers who don't do a lot of this work is that it sometimes is the same person. And people just see Lady Gaga performing. But from a lawyer's perspective, I'm seeing two different people on stage at the same time. I'm seeing Lady Gaga, the performer, being paid to hold a microphone up and sing and play the piano. That's one Lady Gaga I see. And then at the exact same time, I'm seeing an entirely separate person who wrote the song. And all of her business dealings on both sides of that equation are actually quite separate, and she's getting income two different ways.
Now, for example, let's say that I'm what's called a cover band, which means that I play other people's music. I play Lady Gaga. I play Train. All sorts.
That would be an interesting band that played Train and Lady Gaga. That's kind of cool.
It would be.
Where's your band playing, Dennis?
Now the question is, if I'm playing those other songs, do I owe money to anybody?
Well, that follows on from what we were just discussing, that if you're a cover band, you're artists, you're playing music, and you're going to get paid wherever you're playing for showing up, holding your instruments or singing and doing that. That's great. You're getting paid for that. But when you do that, you're also using the songwriting that you don't own, doesn't belong to you, belongs to Lady Gaga, belongs to whoever that songwriter was. And the music industry has set up ways to ensure that when you go out there and professionally play in public or make a record, that those songwriters don't get left behind. Because think about it. If you play live, your cover band plays live performances, and let's say you make $1 million a year, well, I'm sitting here thinking, well, what happened to the songwriters? They make nothing. You just made $1 million playing their songs. And so the music industry has figured this out. And the main way that it's covered with live concerts, radio broadcasts, is that the songwriters and the music publishers they work with, those business partners, all got together and created a big collective organization. One's called the American Society of Composers, Authors, and Publishers, for example, which tells you who their members are. And when they all got together, they had enough business ability, enough lawyers, enough accountants, enough people sending out letters and, doing contracts on the computer and everything, so that they could license all the radio stations and all the clubs and all the concert halls. So the way it works is the clubs, the bars, the concert halls, the radio stations, they send a license fee to this collective organization that represents songwriters, and then that organization has the job and the task, which is a big task, of figuring out how much money goes to Lady Gaga, how much money goes to John Lennon and Paul McCartney or whatever. So there's a system in place. It makes sure that when music is publicly performed, that the songwriters get paid, and it's done through these big licensing organizations. Like the ASCAP is called ASCAP. There's another one called Broadcast Music Incorporated. It's called BMI. And that's how they handle the live performances. When record companies make recordings, there's a similar concept. There's a way for the money to flow from the record label to the music publisher, so the songwriters get paid when the records are sold or streamed, as is the case today.
Yeah, the hard ones obviously are when you're playing a high school dance or something like that. Who's keeping track of that? But there's probably not enough money in that to really matter.
Yeah, well, first of all, believe it or not, high schools, most people don't bother to ask high schools to take out these licenses. They figure the primary job of a high school is to educate, the youth of our nation, and they tend to not be licensed usually. But where the licensing does take place is every place that is a business using music to its advantage. And what that means is, music is wonderful. I mean, if I'm shopping at a mall, which, by the way, I almost never do. It's a funny metaphor, but I'll give you an example. The people who own malls, they want to make your experience there pleasant. They want you to stay. They want you to spend money. They want you to have a good time and feel good. It's good for business. And so what do? They play music at the mall through the loudspeakers. And that's a classic example of a business using music to help its business. And concert halls are the same way, a more direct and obvious connection. Obviously, concert halls make money selling tickets so people come hear music. And the philosophy is generally that anybody who's using music in some sort of setting where the music has value, which enhances their business in some way, then the songwriter should get paid. But your example of a high school, they're actually mostly accepted. There are exceptions, and there's like classroom education, church services, veterans groups, elementary and high school education, where they're not really in the music business. But the exception would be, of course, if a high school auditorium hosted Lady Gaga, to come give a real concert, happens to be in a high school, then obviously that's a business proposition.
Absolutely.
There has to be all the appropriate licensing in place.
Okay, well, we're coming up on our last break before we go off the air, but we'll be back after these words with more from Corey Field on the do's and don'ts of entertainment law. Welcome back. You're on the Legal Line with Dennis Kennelly and our guest, Professor Corey Field from USC Law School. And we're talking about the do's and don'ts of the entertainment industry, specifically music publishing. So we've talked about your role your former role as a publisher. Why don't you explain to the audience exactly the differences between an agent, a manager, and an attorney? What role that they play in the musician's or the songwriter's career?
Oh, okay. Well, agents and managers and attorneys are part of the team of a successful artist, and I'll explain how those roles break down in principle, although in practice the agent and manager roles can get a bit blurry. But in essence, and this is especially true in California, which has very specific laws regarding agents and managers, agents are representatives who get someone work. So if you're a musician, an agent is sometimes called a booking agent, and their job, in theory, is to say, hey, there's a nightclub that is looking for a band, and this is what they're paying, and it's work for you, and I'm connecting you with that. Although, of course, that can go right up the scale to very large tours, or it can be other things that an artist does in their career. So the theory is that an agent gets the booking opportunity. The personal manager is more of a guru. The personal manager's role, in theory, is to sort of say, okay, you've got 3 or 4 possible gigs or jobs your agent has sent you. Here's the one to take that's going to best suit your long-term goals in your career. This is what's going to mold your image. This is how you're going to be presented to the public in the market. And they kind of they're advisors. That's the role of a personal manager in theory. That's how those lines are drawn. And of course, the lawyer part of the team. Lawyers are very regulated by the laws of each state, and the lawyer is there to provide legal advice. So in theory, if some great opportunity comes along that the agent has brought along, then in conjunction with that licensed agent, the manager and the lawyer can also be part of the team in negotiating. California is quite strict in keeping these roles separate, more than many other states. But that's the principle of how that team operates.
Yeah, California and New York, I think, are the two strictest states on who can do what.
Yeah, New York much less so. New York does have some laws on the books about booking agents representing talent. The cases in New York tend not to pay quite as much attention. Here in California, it is a very solid, bright line, as lawyers say, about the laws respecting talent agents in this state. There's no other state in the country quite like California in that respect.
It's really interesting. Technically speaking, a lawyer, just by virtue of his law license in California, can act as a real estate broker and sell a $10 million house. But a lawyer cannot book somebody down at the local pizza parlor without an agent's license.
Well, I don't know so much about real estate, but what you said about the pizza parlor, I agree with.
I know it's one of the oddest, unusual twists in the law, and the managers, the agents had a very good lobbyist that resulted in that law being passed, and was originally passed for the protection of child actors, as I remember.
Yeah, that's another area of the law that's entirely, its own universe is special laws relating to minors in the entertainment industry. And of course, in music and television and film, that's a big topic because so many stars are younger than 18. It's really common.
I can imagine. We've seen them. We've all watched the development of Justin Bieber, rightly or wrongly. And, who controls his fortune at this point? Is he 21 yet? I think he is.
Yeah, yes, he is a no longer a minor, and so whatever special laws applied to him previously aren't there now for him.
So it's really funny. In the old days, the dream was getting well known enough that a record company offers you a $2 million advance for your next album, and you don't have to pay for anything. And that has changed dramatically, hasn't it?
Yeah, I was just looking yesterday at some sort of YouTube music agreements. The world has really changed. Some shows like American Idol and similar shows do kind of perpetuate that old school model of you get discovered and the powers that be hand you great lucrative opportunities and you go for that incredible ride. But these days, there are so many wonderful ways for people to be their own record label, their own music publisher, to be their own, video production company. And this is the age of the YouTube star. And these days, what record labels generally tell people is, if you want the attention of a record label, the first thing they're going to say is, how many followers do you have on Facebook? How many views did your latest YouTube video have? One of the best ways into the traditional music industry now, if you even want to get in, because these days, with the opportunities out there and a good entertainment lawyer, you can be your own label and your own publisher. If there's demand for you, that's the secret, is the traditional record labels are good in theory at marketing and reaching the public. And that's the thing that some people have managed to replace by themselves using social media. It's just a very exciting new era. The types of deals are changing really fast.
And we will.
Changing.
That is the topic for another show.
Okay.
And because we are running out of time, because this has been enjoyable, and because Professor Field had a lot to say, and it was all necessary. So.
You're very kind. Thank you, and I really appreciate your listeners for tuning in. It's a privilege to be on your show and to talk to your listeners. Thank you.
It's a privilege to have you, and I want to thank our engineer, Aaron Delatorre, and wish my normal producers, Laura Espinoza-London and Nikki London, good luck in the studio. So You've been on the Legal Line with Dennis Kennelly, and we'll be back next Thursday at noon.